Thank you and welcome everyone to Fair Trials and Justicia's panel discussion on remote legal assistance in police stations. My name is Emmanuelle de Bouverie. I work at Fair Trials Brussels office as a legal and policy officer. For those who do not know us, Fair Trial is a criminal justice watchdog with offices in Brussels, London, and Washington, DC. The webinar will last an hour and a half, and there will be time for questions at the end, so feel free to submit your questions through the chat function, and we'll answer as many as possible at the end of the session. Warm welcome to our experts joining me today in this discussion. Their full bios are on our invitation and website, so I'll be brief when introducing them. So first we have Barbel Heinkelmann, a legal officer at the European Commission DG Just. Her main field of activity is in the area of procedural safeguards for suspects and accused persons, and she is the responsible officer for the directive on the right of access to a lawyer, which we will discuss extensively today. We have with us Nicolas Cohen, who is a criminal defense lawyer and partner at the Brussels law firm Cogens. He regularly contributes to strategic litigation projects in Belgium and before international and European courts, and works on improving the rights of suspects, accused persons, and convicted persons. He was the co-president of the Belgian branch of the International Prison Observatory, and since 2019 has been an administrator at Prison Insider. András Kádár is a defense lawyer and co-chair of the Hungarian Helsinki Committee. The Hungarian Helsinki Committee is a non-governmental organization working in the field of criminal justice, among others, in Hungary. As a lawyer, András represents individuals before domestic and international courts, including before the European Court of Human Rights, and he has been a member of the Independent Police Complaints Board as a civilian oversight body elected and operated by the Hungarian Parliament. And last but not least, Laure Baudrihaye-Gérard, our Europe Legal Director. She leads Fair Trials work and advocacy in Europe. So welcome, everyone. To jump right in, we went for a scary title. Is this the end of lawyers in police stations? But these are scary times. And the right to a lawyer is generally at risk in all EU member states. But today, with the pandemic and the rush towards digitalization of justice, we may have a long-term consequences. These circumstances may have long-term consequences on the ability of lawyers to provide effective assistance in police stations. What happens in police custody often determines the whole criminal proceedings. Arrested people are placed in highly stressful environments. Isolation, fear, police pressure, even subtle, and the power dynamics taking place at this very early stage influence the direction of an investigation and the decision to hold someone pre-trial or not. And pre-trial detention can last months and sometimes years. And in turn, detention irretrievably affects people's ability to communicate with their lawyers and therefore to adequately prepare their defense. And I would add, and this is not said enough, that detention also impacts people's ability to keep their job and to pay their bills and to keep the custody of their children, among other things. All of that while presumed innocent. In other words, what happens in police custody can dramatically impact persons' lives. Following the European Court of Human Rights judgment in Salders, the European Union has adopted a directive providing for the right to a lawyer as soon as a person is arrested, prior to and during questioning by the police. This was groundbreaking. This became binding law in almost all EU member states in 2016. And despite the directive coming into force, lawyers, we observe, are still lacking in police custody. in most EU member states. And with the COVID-19 pandemic, the effectiveness of the right has taken another blow, leaving the majority of suspects alone and unassisted when facing the police. Some member states have decided to provide for remote assistance during lockdowns to suspects in custody, either through the telephone or through video link. And the impact of remote assistance on the right to a lawyer and on its effectiveness and how it fits within the legal framework provided by the directive is what we would like to address with our panelists today. And so, without further ado, I would like to start with a little bit of context from Barbel, who was part of the discussions leading to the adoption of the directive. So Barbel, if you can please give us a bit of context, the background to the adoption of the directive, why the European Commission decided to focus on this right, and perhaps also give us a brief definition of the content of the right to a lawyer under the directive. Barbel, thank you.
Yeah, good morning. Hello, everybody. I'm very pleased to intervene as a panelist today in this webinar. Big thanks to Fair Trials for organizing this event, which will be hopefully very useful also. And I will also be very much into listening mode to the practitioners and to the questions and issues participants may raise. When it comes to the context of the adoption of the Access to Lawyer Directive, I think the story starts already in 2002 with the adoption of the framework decision on the European arrest warrant in a record time, which raised concerns as regards the safeguard of fair trial rights. And in that context, already in 2004, the Commission came forward with a proposal for a framework decision in that time on certain procedural rights in criminal proceedings throughout the EU. However, the discussions on this framework decision got stuck in Council, basically because at that time unanimity was required before the entry into force of the Lisbon Treaty. And then when the Lisbon Treaty entered into force on the 1st December 2009, following the so-called Swedish roadmap adopted on the day before, on the 30th of November 2009, the work on the directives on fair trial rights started. And it started with the adoption of the directive on interpretation and translation, followed by the directive on information in criminal proceedings, and then last but not least, I would say the cornerstone of the Access to Lawyer Directive. We should also keep in mind that already in 2008, a year before, there was a very famous case, the Saldus case, which is probably known to all of you, which focused on the right of access to a lawyer and stated that this right should be provided from the first interrogation of a suspect by the police, unless it is demonstrated in the light of particular circumstances of each case that there are compelling reasons to restrict this right, and that the rights of defense will in principle be irretrievably prejudiced when incriminating statements are made during a police interrogation without access to a lawyer. That because those statements might be used for a conviction. In this light, the Commission came forward with this proposal on the right of access to a lawyer quite quickly in 2011. It was a proposal on the right of access to a lawyer and to communicate upon arrest. So it took together the so-called measures C, a part of the measure C, and the measure D of the Swedish roadmap. And there was one part which was left for later, that was the right to legal aid, because of the urgency in the light also of the Saldus jurisprudence, and because of the rather controversial aspects related to legal aid, where we then only had the directive adopted in 2016. So the Commission proposal dates of the 8th of June 2011, and was then debated until 2013 in Council in Parliament. I find it quite interesting that while Saldus focuses on the right of access to a lawyer in general, the directive becomes much more concrete. And we should, when we look at the directive, always recognize that there is a difference between the right of access to a lawyer is basically regulated in Article 3 of the directive. And there is a difference between Article 3.2, which describes the starting point of the right, and 3.3, which is describing the content of the right. And in this logic, the directive sets out in its Article 3.2a, so to speak about the starting point of the right of access to a lawyer, that this right starts already before the questioning. 3.3a and b then describes the content of the right of access to the lawyer, and also 3.3c. There, the directive is pretty clear that the right of access to a lawyer refers to both meetings and other forms of communication. That's the content of Article 3.3a, which states that suspects and accused persons should have the right both to meet in private and to communicate the lawyer, including prior to questioning by police and other law enforcement authorities. The two related recitals also explain, it's the recitals 22 and 23, that they explain these concepts further, and they refer to so-called practical arrangements which member states can make. And that's also quite an element which is quite important, that obviously member states, in the respect of their legal traditions, can make such practical arrangements, which should, however, not prejudice the effective exercise or essence of the right to meet or to communicate with the lawyer. Another interesting recital is recital 24, which refers actually to a telephone conversation, but reserves this to only certain minor offenses, and clarifies that limiting this right to telephone conversation should only restrict it to cases where a suspect and accused person is not questioned by police or other law enforcement authorities. So I think that the directive is quite clear here. Similarly, the directive makes a difference between active participations of the lawyer in questioning and the attendance of the lawyer during other evidence gathering acts described as identity parades, confrontations, reconstructions of the crime scene of the crime. And again, the related recital 25 explains the concept of effective participation of the lawyer in questioning, further as being the opportunity for the lawyer, in accordance with the procedures of national law, to inter alia ask questions, request clarifications, and make statements. Whereas recital 26, related to other evidence gathering acts, describes the attendance of the lawyer as the presence of the lawyer. So in questioning, the lawyer should not be constrained to sitting in a corner and watching what's going to happen. That's the idea behind it. From all of this, I think it flows that when we negotiated this directive, the co-legislator had in mind the physical presence of the lawyer when it came to the meetings, when it came to the effective participation and also the attendance. However, in the ultimate resort, the interpretation of these terms will be reserved to the Court of Justice of the European Union, and this court might also take into account the developments of the situation in the civil society and in the context of civil criminal procedures. So obviously, yes, it is. It was thought as physical presence, but today we all speak, and since March speak about meetings and virtual meetings and physical meetings. So it will be open to the interpretation by Court of Justice in the end, ultimately. But the effectiveness and the essence of the rights, of course, should not be jeopardized by any setup of communications and meeting with a lawyer. Yeah.
Thank you very much, Barbel. I think this was extremely comprehensive, and it sets the tone for the rest of our discussion. The directive is pretty clear on what the essence of the right requires, and that is physical presence. And perhaps moving on to what is the assistance and what is required of lawyers in police stations. I'd like to give the floor to Nicolas to perhaps give us a bit of context on what is being arrested, what it means to be arrested. What is the context of police stations in your experience as a criminal defense lawyer, and what is the role of lawyers under the directive?
Thank you. Hello, everyone. It's another point of view after the law. It's the law itself, and the rule having a lawyer assisting you during police interrogation is extremely important. That is the law, but then there's the practice, and the practice says that it is obviously important. It may be dangerous sometimes. We have all to be very careful. It's not because there is a lawyer that the right is effectively protected. So at first, maybe I will focus on detention of audition for people who are detained. Which is the most stressful and the most problematic situation. When people are not detained, it can be problematic, but it's a little different. Most people are interrogated by the police without being deprived of their liberty, so they can leave at any time. Generally, they don't know it, and generally the police don't remind them that. But if you are not brought into the police station with handcuffs, then you have the right to leave at any time. But if you are brought to the police station being detained, then there is a very specific situation, a stressful situation when you are at the mercy of the police, not for violence sometimes, but especially for the questioning and interrogating. Meanwhile, it is a very important step of the investigation. So it's very strange that we are all talking about fair trial, but the very beginning of the trial of a person, the moment when she knows she is being investigated at, because the investigation might have started a month or years ago, but at this very moment, which is very important, that it is quite unfair situation. Because she is talking to people being detained by those people. And we have to balance this. It's necessary. We did not find a better way to organize prosecution, but knowing this, we have to organize and balance this inequality. So the idea is to bring a lawyer in. actually it's very simple. You bring someone who is a professional of the law and who is by principle the person who might have the trust of the integrated person and might accompany her and assist her during the trial afterwards. Sometimes the lawyer knows the person, and this is not really the situation I will talk about here, because when the lawyer knows his client, when he comes to this situation, it is much less stressful, obviously. I think the very important situation we have to focus on is that the situation of the people who are brought to the police station, being detained, and with no lawyer. And they are asking for a lawyer. So they have this right to legal assistance. And the police call the lawyer. There is this organization that the lawyers provide someone who may assist the person. At first, it can be a phone call. So people are always told you can ask a lawyer, and the police usually says, if you ask a lawyer, you will have to wait 2 more hours in detention before the lawyers arrive. So it's also a leverage that they use to fasten the procedure. And when people say, I want to call a lawyer, I want a lawyer, they say you can ask for a lawyer to come, or you can call a lawyer and maybe see if the lawyer will actually come or not. And lawyers are also told this, that they receive a phone call and that they decide if it is useful or if it is the best decision to come or not. Which is sometimes very clear, and most of the time not clear at all, because you will during a phone call you get very few information, and especially if you don't know the person you're talking to, it's almost impossible actually to decide where it's the best situation to come or not to come to the police station. When you know the client, for sure it goes faster, because you have precedent, and you know how to focus on the important things, and you have the link of trust which is already settled. When you don't have this, I think the lawyer must not have the choice to come or not. He or she must just come. When you arrive, you may be a counterpower. If you, by being there, you observe, you can see, and you can assist the person. You may not impeach the police from doing the job, and doing a police interrogation in a complicated case is difficult. So it takes a while, it takes some time, and the lawyer can, I really understand that the lawyer cannot intervene at any times. Otherwise, sometimes it's impossible to do the police job. But the lawyer must have a possibility to intervene, and obviously to have the police write down what he or she is saying. But here actually I jumped to the interrogation part before saying what's happening when you meet your client at the police station. You have 30 minutes when you meet someone at the police station in Belgium, 30 minutes when you meet someone you don't know for a crime you barely know by the information the police told you, and you have no trust built with this person. So you have 30 minutes to make the basis of this trust, to gather personal information, to know who you are talking to. Yeah, you mentioned, Emmanuel, the fact that people might have a job, family, etc. You have to know this before you enter interrogation, and the consequences of this interrogation. You need to gather also factual information to be able to give an orientation on to initiate the strategy of the defense. What is good to tell to the police? Is the situation quite clear and you can go and just express yourself? Is the situation unclear and you might wait until we have access to the file and discuss on at least a more fair point of view? Because you all have to remind that at this stage, obviously, you didn't have access to the file, so you don't know what the police knows before the interrogation. I admit this, it's a way of doing, but you have to build a strategy on this aspect of the investigation. After this, when you are in front of the police, if you don't have a lawyer, the police will present themselves as doing the investigation on charge and discharge. They will tell you what the law says. The investigation is going to find out to look at what is incriminating you, and looking also at what is showing your innocence. But that's a myth. That's obviously a myth if you consider that every actor of the criminal chain is protecting this balance. Obviously, all the actors have a goal. They are humane, they are biased by this. It's okay if you admit this. If you admit that a fair investigation is not fair because everyone is impartial, it's fair because the whole system brings checks and balances. That's how it works. So the police, they usually say to people, don't worry, we are going to look into what you are telling us, and if you are telling the truth, we will help you to prove it. They will not. If they arrested someone, it's because they think that this person is guilty. Otherwise, they wouldn't have arrested this person. They would just have summoned this person to come to the police station. So it's very important to just keep this in mind, so you know that the whole system works if everyone is intervening at his good place and doing the best of his job. Very often, the police explain this, and the lawyer, sometimes the person says, well, I will wait for my lawyer, I will see after the interrogation. So this checks and balances, it works if the lawyer comes, if the lawyer is present. And I could also go into more details, but maybe a little later, about what is happening when the lawyer is not there. Okay, because it's also another field of discussion.
Thank you, Nicolas. This again, I think super comprehensive and useful. You mentioned, the checks and balances and the role of lawyers to balance out the fact that the investigation is obviously tilted towards considering the person as guilty even before there is a trial. And perhaps on this fairness of the system and the checks and balances aspect, András, the HHC has published a report a few years back on a comparative report in 7 EU member states on police violence and police misconduct. And so this there is a link between the likelihood of misconduct and violence and the presence of lawyers in police stations. And the CPT, I believe, has recently published a report on Portugal, raising the fact that it is police misconduct is not just a matter of a few bad apples, and it is in many EU member states a systemic problem. So perhaps can you fill us in on the role of lawyers in relation to that problem?
Yes, thank you. Thank you for the invitation. Welcome to everyone. Well, the CPT has actually a very, very clear standard on access to a lawyer, and this links into what Barbel was saying, that in the CPT standards, access to a lawyer means the direct physical presence of the lawyer. I think it's important to emphasize. They make this interesting distinction between the presence of a lawyer as a safeguard ensuring a fair trial, and the presence of a lawyer ensuring being a safeguard against ill treatment. And they emphasize that it's their role to look into ill treatment matters, but I think it's very obvious that if ill treatment takes place, then that compromises the fairness of the trial as a whole. So I don't think the two can be completely separated, and they make it very clear that physical presence is key. I will shortly come to this. Just a couple of words about the research. Yes, we looked at 7 countries, and basically what we wanted to see is whether it is legal or non-legal factors that play a more important role in decrease of the prevalence of torture in systems. And we found that while non-legal factors are extremely important, institutional cultures are extremely important, it is possible to create a legal framework that reduces the prevalence of ill treatment, and access to a lawyer is an important element of that. We found that countries where the prevalence was low or relatively low were the ones that generally did better in providing access to a lawyer. CPT, yes, with regard to Portugal, they came up with this conclusion, and in their report on Portugal, they also mentioned that one of the key problems was that people who didn't have a retained lawyer met their ex-officio lawyers just 48 hours after the beginning of the detention, which plays a role in this kind of widespread practice of ill treatment. I also checked other CPT reports from the year 2019 because our research is 4 or 5 years old now. And I found that in the Polish report on a visit in September 2019, the CPT also mentioned that ill treatment is not unprecedented in the Polish system, and access to a lawyer is actually highly problematic in the Polish system. There was also another CPT report concerning a visit in Greece last year, where also widespread ill treatment, especially against members of the Roma community and foreign nationals, was identified as a problem, and access to a lawyer was also a problem. So what we can see is that these two go hand in hand. And when we talk about, prevention of ill treatment, we have to remember the direct prevention. If the lawyer is there, then obviously the chances of ill treatment are significantly reduced. But we also have to remember that the presence of the lawyer, the physical presence of the lawyer, has a kind of indirect preventing effect by making impunity less likely. How? What we see and what we saw in our research and what I see in my own country is very high latency of ill treatment. There are very few reports made because people are afraid. When there's an ongoing criminal investigation against them, you can understand why. Very few of these few reports lead to prosecution. And actually, interestingly, the success rate for prosecution tends to be lower for these kinds of offenses than any other offense. It's interesting, in the Hungarian context, the success rate of the prosecution is 95% in all cases, but when it comes to ill treatment, it's only around 66. So there's a statistically significant difference. I think the main reason is, there are two main reasons. One is that usually these kind of actions take place in closed institutions when, only police officers are around, so it's difficult to get the evidence. But also it's because there is this kind of institutional culture of, siding with the good guys. When the prosecution has to decide whether to go forward with a case like that, there is a suspect on the one hand who claims to have been ill-treated, and the police on the other, and there are the institutional links that make it difficult for the prosecution to carry on in an unbiased manner. And this is where this whole thing, the indirect effect comes in. So even if the lawyer comes after the ill treatment has taken place, the lawyer can notice the signs of ill treatment. The lawyer can take a picture of injuries that will soon go away, like the imprint of a palm on a face. The lawyer, if the lawyer comes in a timely manner to meet the suspect, can identify the concerned officer, can ask for, records within the police station, who are the officers on duty that the suspect may not be able to know. The lawyer may seek witnesses on the spot. Has anyone seen the person coming in? Has anyone seen whether he had injuries when he was coming in? The lawyer can also make sure that if a person complains of ill treatment, that person is given time before he or she is interrogated, because obviously ill treatment and being interrogated right after it compromises the fairness of the procedure. And the lawyer can also make sure that those person who ill-treated the suspect, or who the suspect claims to have been ill-treated by, are taken off the case. So, I mean, there are a lot of things that the lawyer can do besides preventing ill treatment by his or her presence simply. And just to give another incentive that is, you know, on the positive side for the law enforcement agencies, like audio-visual recording, the presence of a lawyer also means a guarantee for the police officers against false accusations of ill treatment or abuse, which reduces that the evidence might be thrown out later on. So I think it's very clear that from the point of view of ill treatment and fairness as a whole, the physical presence is crucial.
Thank you very much, András. Indeed, it is hardly conceivable that a lawyer would be able to do all that on the phone. Laure, if you want to step in to discuss other, so we've covered the role of lawyers with respect to the fair trial aspects and how to balance out the fairness of the proceedings. Nicolas mentioned that in András, the more systemic impact of lawyers on police ill treatment. But whether a lawyer is present or not at this very early stage also has an impact on a whole range of other rights. So perhaps you can give us a bit of insight on that.
Yes, sure. Thank you. So yes, as we've heard, when you're held up in police custody, you're alone and you're cut off from the outside world. And in that inherently stressful situation, many are not in a position to understand what's going on and what they should do. And research suggests that many arrested persons do not understand their rights, or sometimes also the charges against them. The language used is too technical, and they're under such huge stress that it hampers the abilities to understand. So the right to access a lawyer serves as a gateway to enable persons to understand and exercise their other rights, such as their right to legal aid, to understand that they may not be required to pay for the costs of the lawyer's presence in the police station. Also the right to access certain information in your case file, for instance, to understand the basis for your arrest and the basis for your detention, which are obviously key information to have if you want to challenge that arrest and that detention. And of course also your right to silence and not to make self-incriminating statements. So without the right to a lawyer, these other fair trial rights may be in practice completely ineffective. And we also see how lawyers help ensure that people exercise their right to interpretation, for instance, in practice, when people don't speak or understand the language used by the authorities. The European Union member states are required to implement a system to assess the language skills of a person and ability to understand the languages of the proceedings. But in practice, we know that this is not always verified. And again, it's often up to the lawyer to make a request for interpretation. And when we see the staggering number of foreigners who end up in detention, particularly in pre-trial detention, this right is absolutely key to enable that person's effective participation in the proceedings. I was just looking at received the statistics from Austria, for instance, for 2008, 65% of pretrial detainees in Austria are non-Austrian nationals. And Austria is far from being an exception. Belgium, Luxembourg, Greece, for instance, have all disproportionately high rates of foreigners in pretrial detention. And the lawyers may also be in a position to identify a person's vulnerability generally. A huge number of persons arrested are young, have mental health conditions. Many have multiple complex needs. They may suffer from drug or alcohol addiction. Some are homeless. And again, research shows that member states do not have adequate mechanisms to identify such vulnerabilities that require specific and enhanced safeguards to ensure that vulnerable persons can exercise their fair trial rights. So access to a lawyer is really a gateway right to these other safeguards. And it's key that this happens as early as possible after arrest. Because what happens during those initial 24, 48 hours in police custody will affect the overall fairness of the whole proceedings, all the way to sentencing, and may well determine a person's whole life, as you pointed out, because living with a criminal conviction can not only lead to imprisonment, but all sorts of other consequences on your life, your work, your family. So this has huge implications. These initial 24, 48 hours have huge implications. And the immediate outcome of police custody is to determine whether you will end up in pretrial detention. What you say to the police is likely to determine whether you are detained prior to trial. The perception that you convey, the statements that you make will form the police's view on whether detention is necessary. And in turn, the police's view will inform the prosecutor and determine their decision to make a motion for pretrial detention. And statistics show that once a prosecutor makes a motion for pretrial detention, an overwhelming majority of requests are granted by courts. And then if you end up in pretrial detention, your ability to participate in the preparation of your defense is dramatically impaired. So in police custody, you may also come under pressure to confess, perhaps even to something you haven't done. And these statements you make will also influence the next steps in the investigation. And where these statements are obtained through pressure, for instance, just the pressure, the threat of being placed in pretrial detention, to confirm, for instance, what the investigating authorities' theory of what happened, rather than seek an objective view of what actually did happen, there's a high risk of miscarriage of justice, unless you have that system of checks and balances that Nicolas pointed out to. And the presence of a lawyer during the police interrogation constitutes an important counterweight to that vulnerability of any suspect in a police station when facing authorities who hold overwhelming powers over you. And that power imbalance is always present in interactions between people and police officers, especially when you're held in custody. So these safeguards that are set out in the legal framework are enshrined to design, are designed to ensure a fair outcome, to limit the risk of people being wrongly convicted, and also to ensure a fair process in which the accused person is able to participate effectively and actively in the proceedings. And the gateway to these rights is the right to access a lawyer.
Thank you. Thank you very much, Laure. So obviously, this right has an impact on other procedural rights from EU directives. I think I can jump on. There is a question. So the right, obviously, to a lawyer is not absolute, and the directive, as well as the European Court of Human Rights case law, provides for the possibility to derogate from the right in some exceptional circumstances. And I think this touches upon what Krasimir asked in the chat, and the link to the current pandemic. So Barbel, could you please walk us through what are the limits to the right, and what did the directive envisage in terms of derogations, and how these are defined? Thank you very much.
Yeah, hello again. I think the explanations will be once more a bit technical, because the directive is technical, and again, it's based on the difference between Article 3.2, the starting point of the right, and 3.3, the content of the right, which is very important. There are two types of derogations in the directive. Article 3.5, which relates to cases of geographical remoteness, and Article 3.6, which is related, which is related to the preservation of crucial rights of third persons and the need for investigations. I'm excusing myself for working remotely at home and having a cat. Article 3.5 of the directive provides for the possibility to derogate from the application of the right under 3.2c, which is the right of access to a lawyer without undue delay after deprivation of liberty. So the starting point of the right in cases of geographical remoteness. It only refers to the starting point, and it does not refer to the content of the right, which is the presence during investigative acts, the possibility to meet and communicate before and during the questioning. And therefore, in concerning these situations of geographical remoteness, Article 30 of the directive explains that the authorities in these situations are not in a position to question the person or to carry out any of the investigative or evidence gathering acts provided for by the directive. I think that's very important. When it comes to geographical remoteness, the discussions were quite lively when we had the discussions about the adoption of the directive. There were two examples given for geographical remoteness, which are also reflected in the recital text of the directive. Those were overseas territories, so the lonely island, where it is factually impossible to get a lawyer quickly, or military operations in this context. And in that context, the directive makes also a reference to the possibility to use telecommunication to at least ensure a contact with the lawyer, but still without the possibility to question or to proceed to evidence gathering. I think that is very important. The other derogations are the ones under Article 6 of the directive. Those are derogations which are extremely limited and under very strict conditions linked to the needs of to safeguard crucial rights of third persons and the needs related to investigations. But if you read the text of the directive in this respect, it's a very, very strict conditions. And in these cases, there can be questioning or evidence gathering, but only to the extent which is justified by these needs. So it would not be an extensive questioning, it would only be a questioning which is linked to the need to trigger the issues related to the needs which are at stakes, which are the urgent need to avert serious adverse consequences for life, liberty, or physical integrity of a person. So not, for example, financial needs, or where there is an immediate action necessary by the investigative authorities, which is imperative to prevent substantial jeopardies to criminal proceedings. So these are very, very strict conditions, and their questioning might be possible. I hope I could clarify this point, but it's really important that the Article 3.5 only provides for a derogation for the starting point, while Article 3.6 would also provide for the possibility to derogate from the content of the right of access to a lawyer.
Thank you very much, Barbel. This is really enlightening, and it's very likely that many member states pre-COVID or during COVID are not applying these derogations as they were envisaged by the directive. So perhaps not to spend too much time on how the right is implemented currently, we understand that there is this possibility to derogate from the right in exceptional circumstances, yet the right is not very well implemented in the majority of EU member states. I don't know, Laure, if you want to touch upon that very briefly, and then we can move on to the reasons why the right is not implemented.
Yeah, sure. I mean, we've seen how the EU and the ECHR have been able to initiate a wave of reform in domestic legal systems to enable the right to lawyer prior to interrogation and during interrogation. But it's far from job done when it comes to translating that right into practice. And let me just take the European Commission implementation report of last year, of 2019, which highlights important divergences and recognizes that these may limit the effectiveness of the rights provided by EU law. First, in some member states, we don't even have a mechanism yet in place to facilitate access to a lawyer. So if you don't happen to have a lawyer's number in your back pocket, you can't exercise your right at all. And then even when there is such a mechanism in place, the EU's Fundamental Rights Agency highlights in their report also of last year, of 2019, difficulties for people in police custody to obtain prompt access to legal assistance. And then we see issues with the right to consult a lawyer prior to questioning. In the European Commission report, we see that in 9 member states, they've only partially transposed the right of access to a lawyer before questioning. And in 2 member states, that right is not expressly stated during questioning, before questioning at all. And then the ability to meet in private and communicate with the lawyer is only partially transposed in 11 member states, and this has a negative impact on the right to confidentiality. Added to what we know from our research is that even if the law does reflect a right to confidentiality, in practice, the facilities for confidential consultation prior to interrogation is not often provided, with lawyers frequently telling us that they have to meet their clients in corridors, in front of police officers, and often for very short periods of time, as Nicolas pointed out. And then we also see issues when it comes to the right to a lawyer during questioning. Again, the European Commission reports indicate that 16 member states only allow lawyers to participate at the end of questioning. And of course, as Nicolas said, there is a need to let the police carry out their role and conduct the questioning in a way that's necessary for the investigation, but completely limiting the role of the lawyer until the end of the questioning clearly undermines the effectiveness of their presence to ask questions, to request clarifications, and to make statements. So when the pandemic hit us, this right to a lawyer in police custody was far from being a reality, and a lot of work is in progress, bringing together lawyers, policymakers, civil society, academics, to try to make this right to a lawyer in police custody a reality.
Thank you. Thank you very much. So this means that states have not waited for the COVID-19 pandemic to fail to implement the rights of access to a lawyer in many ways, and for many reasons. And also many member states have in fact implemented this right by providing remote assistance and by incentivizing remote assistance, whether and mainly by providing phone assistance prior to questioning. And so one reason perhaps for this very poor implementation is the lack of sanction of the absence of a lawyer at the police station, or a sanction of the violation of the right to a lawyer. So perhaps, András, if you have insight on how the right is sanctioned, and in particular on the lack of exclusionary rules in Europe, and how that impacts or incentivizes the police to not to implement or guarantee that right.
Exclusionary rules, I think, can be a very important element in ensuring compliance. Again, coming back for an example to our study from 2016, there was an interesting finding that in some jurisprudences, in some jurisdictions, there is a kind of reverse burden of proof when then the suspicion of ill treatment comes up, and if a suspect has injuries, then in a way the burden of proof is reversed, and it is for the authorities to prove that they were not the result of ill treatment. And I'm not talking about the ECHR case law here, I'm talking about criminal procedures in the domestic jurisdictions. I think probably in the Czech Republic and maybe in Northern Ireland, the testimonies had to be thrown out if there were injuries on the suspect and if the authorities could not prove beyond reasonable doubt that those injuries were not a result of ill treatment. And I think it shows that exclusionary rules can be very efficient. And we found that those jurisdictions where this was the rule were the ones that were doing, you know, better in the overall situation concerning ill treatment. Now, an interesting example from Hungary. Actually, recently I read it in a closed Facebook group for defense counsels about a case when a juvenile was taken into police custody and interrogated about selling some marijuana to friends without a lawyer, although having a lawyer there would have been the legally required procedure. And what happened that he testified, he didn't exercise his right to silence, and in his testimony he named 3 of the persons to whom he had sold drugs. And those persons were obviously also taken into custody, interrogated, and they testified against him, in a way confirming that, yes, they got their marijuana from him. And the situation is like, by all probability, the testimony of the first suspect will be thrown out for the lack of, you know, access to a lawyer. And the fact that he was interrogated without a lawyer being duly notified and being able to be present. However, you know, the subsequent testimonies of the 3 persons he named in his initial testimony will not be thrown out and will be sufficient to actually convict him by all probabilities. So this is the classic poison tree issue. But we have to see that, you know, unless there is some consequence of the police's omission here, then the police will not be, you know, incentivized to implement the provisions properly, because they actually got what they needed by violating, I think, this very crucial rule. So we also have to look into this. The other thing we have to look into is legal aid, because actually it's not only convenient for the police, but we have to face it might be convenient for the lawyers to only have to make a phone call. And then the question is, you know, how is and this is obviously a problem when we come to legal aid lawyers, and not so much with regard to retained lawyers, is you know, there is this kind of clash between professional ethos and the difficulty of waking up in the middle of the night, getting dressed and drive to some remote police station. So here the question is also interlinked with legal aid, the financing of legal aid, and quality assurance in the legal aid system.
Thank you, András. I think that's a very valid and good point. And so you've highlighted how the system, you know, the lack of exclusionary rules, or the lack of satisfying exclusionary rules that take into account the fruit of the poisonous tree doctrine, contrary to the anecdotes that you outlined. So the system creates incentives for the police not to wait for a lawyer to be present, or to pressure the person not to have their right implemented, because there won't be any sanctions. So the statements gathered by the police in the absence of a lawyer will be able to be used either in the case in chief, during, you know, in the evidence, or through in the investigation, to lead to other statements that will then be used, as you explained, to find the person guilty. So, and the other incentives that the system creates are with respect to lawyers, indeed, and that's something that I think we will touch upon later. So it is clear that the EU has not legislated on what effective remedies for breach of the right to a lawyer should be, and the European Court of Human Rights has not done that either. And this clearly seems to have an impact on how the right is implemented at a domestic level. If there's no sanction for a violation of the rights, the system will be incentivized to continue producing these uncounseled statements at the very early stage of the proceedings. So I was hoping that Nicolas or Laure could tell us about the impact of remote assistance in police stations, or the impact of having no lawyer present, physically present in the police station. So I know that Fair Trials has done research during lockdowns, identifying through surveys, EU-wide surveys, the practice of remote police assistance during lockdown. And Nicolas, you have experience from the ground as to what it is. So I don't know who wants to go first.
Please go, Laure.
So Laure.
Thank you, Nicolas. So yes, the COVID-19 outbreak and the responses to it are having an unprecedented impact on criminal justice systems. And at Fair Trials, we're committed to ensuring that the rights of suspects and prisoners are not forgotten during the crisis. So back in March, when the pandemic hit Europe, we launched the COVID-19 Justice Project, and with the help of the members of our LEAP and Justicia networks, so bringing together engaged criminal defense lawyers, civil society, and academics, we started tracking how justice systems and fair trial rights were being affected. And then over the summer, we conducted a survey of defense practitioners, again, thanks to our Justicia partners and LEAP members in 8 different European countries. So Belgium, England and Wales, France, Italy, Latvia, the Netherlands, Romania, and Spain. And we wanted to know what the practice on the ground was looking like. If you are arrested during the pandemic, would you have access to a lawyer? And what we heard was that the situation depended very much on which member state you are in, but also within the member state, which police station you are held up in. And even depended on the attitude and the goodwill of individual police officers handling your detention and of the lawyers appointed to your case. But we did also see some more general patterns emerging. Many police stations restricted access to manage COVID-19 infections, and lawyers faced many difficulties in accessing police stations to attend interrogations by the police and to provide prior confidential consultation. And we also saw many lawyers refusing to go into police stations. It was unclear in some countries whether they were allowed to leave their homes, whether leaving their home to go to the police station would breach lockdown rules. And even if there isn't a breach of the law, there's also a fear of obviously contracting COVID and an uncertainty as to the sanitary measures in place in police stations. So the right to in-person legal assistance was severely restricted during the pandemic. And where legal assistance in police station was provided remotely instead via telephone or video link, our survey responses indicate that the use of remote legal assistance in police custody is a poor and inadequate substitute for in-person legal assistance. First, it was harder for lawyers to interact with their clients and to build a trusting relationship through remote communication, in particular with new and vulnerable clients. Another point was that it was generally more difficult to provide advice to your client and to take instructions from your client before interrogations due to insufficient time for the consultation over the phone. And the vast majority of lawyers surveyed also expressed serious concerns about the confidentiality of client-lawyer consultation in a remote setting. In practice, lawyers could not discuss crucial or sensitive matters with their client due to the absence of adequate facilities to guarantee confidentiality. Clients had to contact their lawyers often by telephone situated in open areas. And in some cases, we heard that calls were facilitated by police officers who remained present and therefore could overhear the conversation between the client and the lawyer. And then lawyers also expressed concern about not being able to prevent coercive techniques and ill treatment by the police, including in particular pressure not to call in for legal assistance. So plenty of concerns about remote assistance were reported. And what worries us, and the reason that prompted us to convene this meeting today, is that this situation is obviously ongoing as we're still all facing restrictions related to the pandemic, but also because the pandemic appears to be creating an opportunity to normalize remote legal assistance, despite all these concerns. And we're worried that we're heading into long-term changes that see remote legal assistance becoming the norm. We already have research indicating that lawyers may be disincentivized from attending police stations due to the perceived convenience of assisting their clients remotely over the telephone. Some are inclined to limit their assistance to a pre-interview phone call, advising the person to remain silent during the police interview, and that's that. And when suspects have the choice between remote and physical assistance, they may also be inclined to waive their right to physical assistance during that initial phone call due to the perceived inconvenience that it creates to call a lawyer in, or also just to prevent unnecessary delays, sometimes as a result of active dissuasion by the police officers. And now I'd like to just pause here on the impact of this initial phone consultation on waivers to the right to have a lawyer present during the questioning, because in many countries, even before the pandemic hits, as we pointed out earlier, the right to access a lawyer starts with telephone assistance before in-person assistance. And there is some research in Scotland, for instance, back from 2018, that indicates that this initial remote consultation can lead to waivers of the right to a lawyer being physically present during questioning. And this obviously has repercussions afterwards on the right to silence and on the quality of legal advice provided. So remote assistance was already a possibility. It was a way of implementing the right to a lawyer in police custody in some member states. And we're worried that the pandemic is giving states the opportunity to extend remote assistance further and to normalize this. But in our view, remote legal assistance cannot be treated as equivalent to in-person assistance, as simply one way for member states to implement the right to a lawyer in police custody, because it doesn't meet the objectives of the right to access a lawyer in police custody, and it doesn't meet the legal standards set by the ECHR or set by the EU directive. The court in Strasbourg has on numerous occasions stated that suspects have the right for their lawyer to be physically present during the initial police interview. Otherwise, lawyers' participation would be merely abstract, in the words of the Strasbourg court. So remote legal assistance departs from the applicable legal standards. And we should not accept legal change to enable remote assistance more widely, because there is very little empirical research on the use and impact of remote versus in-person legal assistance on defense rights. And the research that's there, the anecdotes that we have, and in particular, there's some research when it comes to remote court hearings, for instance, by Transform Justice, suggests that virtual justice, which we could extend to virtual legal assistance, may not be efficient, may not deliver cost savings as it's meant to, and may compromise human rights and confidence in the justice system. So looking forward beyond the pandemic, we think that remote legal assistance must remain a short-term response to an immediate and exceptional crisis, but we need a clear and urgent exit strategy from this approach.
Thank you very much, Laure. Again, very comprehensive. I'm just looking at the chat, and there are many questions. I think one comment from Ellen, who is an interpreter, she again stresses the importance of what happens in the police station, and she says that often she arrives first, and then the police officer pressures the person to waive their right to a lawyer to start the questioning as soon as possible. She also mentions, and I think that is interesting, that neither and that the defense lawyers rarely ask when they arrive what has happened from the time she has arrived in the police station and the time the defense lawyer has arrived. and she mentions that a lot can happen at that stage. Nicolas, do you want to jump in?
Yeah, with pleasure. Actually, I really follow what has been said by András and by Laure on the practical aspect. What is quite funny, actually, is that the lawyer appears as the key actor in this protection, but is also the weak point of this protection. And he is both, he or she is both, because of this humane aspect of the protection. To be efficient, the protection, the assistance of a lawyer must be effective. The lawyer must be there. There is nothing replacing the presence of a lawyer at your side, even if it's just to comfort you at this stage. But it's a very specific aspect of the job, actually. András mentioned it precisely. You have to wake up during the night, be present at the police station. It is not what you've been trained for at the law school, not at all. It's like an emergency doctor. It's a specialty of medicine. It should be a specialty of lawyers too. If we want them to be efficient, if we want them to be to know what they are dealing with, if we want them to be well paid for what they are doing, because it's also a very specific way of payment, especially in Belgium, when you are paid a year and a half after having exercised your job. So when you are a legal aid lawyer. And obviously, the problem is with legal aid lawyers accessing and assisting people at those police station. So it's very specific, and it needs specific skills, specific training, as mentioned also before. If we take some examples, the idea is, obviously, when you bring in a lawyer, you will give protection to people because they have someone on their side, at least assisting and knowing how the questions have been mentioned, because everybody who has looked into the document wrote by the police after the interrogation knows that it does not give a very 100% view of what has happened. Obviously, the questions are not always written as they were asked. Sometimes they are not written at all, and many things like this happen. So you bring in a lawyer, you don't settle the problem of an effective assistance and effective fair trial, but you give some other point of view, someone who looks at the procedure. I saw one question in the chat about the presence of the permanent presence of someone legal assistant in the police station. I would personally be against such a solution. If there is some lawyer in the police station at any time, he will just be one of the friends of the police. It's just normal. It's humane. We have to avoid such situation. Lawyers, they come from outside, and they are some outside protection. It's a checks and balances system. It's not an integrated protection. It does not work. Internal control is not efficient for protecting a fair trial. It's efficient for other stuff, but not for a fair trial. Also, you don't have to forget that people who are in the police station, actually they were brought in by the police without a lawyer, obviously, and this will never happen that someone is arrested in the street and the lawyer arrives in the street and accompanies the person to the police station. So many things will happen in the car, violence sometimes, but also questioning, and the police will report what happened in the car and what they were told by the person in the car. Always, they will say, outside of the interrogation, the person told us that. And so there is this information at the disposition of the judge. When someone after an interrogation is going to a house search with the police, the lawyer does not follow up. So we have to remind that obviously there is no lawyer at any time of the police action in the investigation. It is not a problem in itself, but we don't have to consider that a lawyer being present during the interrogation is a lawyer being present at any time. No, there are much more other times. For the a very quick point on the control of violence mentioned by András before. It's very important, but it's also extremely specific. A lawyer, just by being present and by being really well trained at law school and even have some experience as a lawyer, is not in itself able to help someone who's been victim of violence. Someone who's been victim of violence by the police will not tell someone he doesn't know, even a lawyer, I've been beaten up. It's been extremely traumatizing for me. No, he will not. So we have to know that it is a very specific thing to train lawyer with, and it's very interesting. It's very important, but it's I think very specific. Lawyers are a key actor and a weak point. Last point for me, but which I think is interesting. If we compare, it's a comparison with something totally different. We're not talking about police lawyer assisting at police station, but at the difference between representation by a lawyer or lawyer's assistance in civil proceedings and criminal proceedings. I had just recently a procedure about people who are detained in Syria in the camps, and they are tried in Belgium. And the idea was, we are representing them to ask the Belgian state to repatriate them. And we say we have a mandate, a clear mandate to do this. So we are acting on their behalf in courts. But in the meantime, the federal prosecutor wants to prosecute those people who are in the camps for terrorism. And we say, for this specific question, for this specific trial, the criminal trial, we cannot represent those people because we cannot provide the legal assistance they have the right to, because it's specific legal assistance in criminal proceedings. So it's very interesting that we have this question actually. Assisting someone as a lawyer is different regarding the procedure you are talking about. If it's civil procedure, civil rights, it's more easy to represent people. If it's criminal procedure, and the judge said, if it's criminal procedure, we have to wait for the person to come back. So it's a good example because it shows how specific is a defense in a criminal procedure. I wanted to remind that.
Thank you, Nicolas. And so the court agrees that communication and effective communication with your client is an absolute key aspect of the right
Yes.
to effective assistance. And so I think you highlighted many things, in particular how uncautioned or statements gathered by the police in violation of the right, whether in the car, from the place of arrest to the police station, or even at the police station, but without assistance of a lawyer. Once that statement is out, it's just too late. And once police misconduct has happened, it's just too late because the person won't file criminal proceedings against the police, as András mentioned, and there won't be any effective remedy in the trial process to exclude the statements. And so I think this is again key to stress that without appropriate sanctions, the presence of the lawyer is all the more key because we need this preventative safeguard of having someone physically present there. We're running out of time as usual, and I wanted to give the floor to Barbel to touch upon this digitalization of justice toolbox that the European Commission is currently working on, and that will be, I believe, published in December. And so it is unclear, at least to us, what the toolbox contains and what areas of justice will be addressed under this measure. So perhaps, Barbel, if you can give us some idea of what the toolbox will be, will consist of, and whether, of course, early access to a lawyer in police custody will be part of the thinking.
Yeah, hello again. I just wanted to come back to one little point. Laure referred to the Commission report on the implementation of the Access to Lawyer Directive. And I must say, meanwhile, we have followed up on the situations in the member state. And there are also some encouraging developments there. So I would like to be also a bit positive. We have even had, meanwhile, changes of legislation in practices in some countries. So I think that's also, it's a work in progress, and I think also the Commission report and further contacts contributed to an improvement of the situation. Obviously, when it comes to digitalization and the current work on the toolbox, it's obviously still a bit too early to go into details of what will be in this toolbox. But you should be aware that this toolbox covers a lot of issues. It's a vast exercise related not only to criminal law, but also to civil law, administrative law, to cooperation between authorities, and also to access of to justice by citizens, also in various fields, including civil justice. So I think that's something we should keep in mind. It's a beginning of an exercise. And it is very clear that we are all keeping in mind that digitalization is not an objective in itself. It's meant to improve access to justice and the efficiency of justice, both. Obviously, during the current crisis, there has developed a greater level of use and acceptance of digital tools. I think we all made this experience. And that created an atmosphere that this can be seen as an opportunity also to allow citizens to make more use of digital tools also in the area of justice. The implementation of any actions, and there we are absolutely aware of that, is related to this digitalization exercise, must of course be in full compliance with the fundamental rights of the persons and of the European legal framework. So, for example, the protection of personal data, but also the right to a fair trial in the framework of digitalization. Of course, digital technologies are becoming more and more user-friendly and accessible for a large category of persons. But we are also aware that this must be ensured, taking into account also the needs of disadvantaged groups and vulnerable persons, elderly people, persons with disabilities, persons lacking the means or the e-skills to use such kind of technology. In particular, when it comes to criminal proceedings and in digital environment, special attention needs to be required to avoid any interference with the right to the defense, including the right of access to a lawyer and the right to access to the materials of the case. So the right of access to a lawyer and the confidentiality without derogations will still be needed to be safeguarded. And in this context, an important element when we worked on that in the framework of a mapping exercise was also the possibility of defenders and defense lawyers to use secure distance communications technologically to guarantee confidentiality during remote hearings. So all this will flow into it. The discussions on the toolbox are still ongoing inside the Commission and with external stakeholders. The adoption of the Commission communication is indeed planned for the beginning of December. But the work on this will be going on. And against this background, I would really like to understand that we very much appreciate any contributions to these discussions based on concrete experience of professionals. And I think the webinar today was certainly a valid part of it. I have noted down a couple of points, and we always appreciate very much to if practitioners share with us their experience, with their concrete experience on advantages and disadvantages of the use of digital environments.
Thank you very much, Barbel. So I understand that there will be a focus on the safeguarding of these rights, and in particular for vulnerable individuals as well, as you mentioned, because I think all of our discussions show that there are problems with the implementation of the right to access to a lawyer. But perhaps we haven't stressed enough that for people with specific vulnerabilities, finding themselves arrested and facing the police, this situation might be all the more problematic. And whether alone facing the police or having someone on the phone, I think the communication with some vulnerable groups might be too impaired to permit effective assistance of their lawyer. I don't know if anyone wants to jump in for final remarks. András, do you want to say a few words?
I don't have too much time. I just thought about adding to the list of Nicolas of what things a lawyer cannot do when he or she only talks to the client on the phone. And there were mentions of promises of early release, of threats or prolonged detention in case someone exercises the right to silence. And obviously just telling on the phone to the client that you have to remain silent may not be sufficient when a person is in that situation under that kind of stress. Lack of proper information on rights and procedural consequences, this is something the lawyer can correct if he or she understands how the rights have been communicated. There were, I think, among the questions in the chat, there was, what if a person is not in the state to be interrogated, being drunk, under the influence of drugs or alcohol? We have seen that a lot. And, when a person is in that situation, you may or may not be able to perceive that through the phone. That person will be asked by the police, of course, are you capable of testifying? And then, obviously the person can be pressured to say that, yes, I am. And then the person will sign the minutes of the hearing. And later on the judge will say, okay, you just signed the records. Are you now claiming that you were not in the state of mind to be? And this is again something that you can only handle as a lawyer if you're there. Also, omissions from the records. This happens sometimes. I had a case when it wasn't the interrogation of the suspect, it was a confrontation, and the witness with whom the suspect was confronted said that, when we were talking with you, Sergeant, on the corridor, I told you this and you told me that. And then, I'm pretty sure that wouldn't make it in the records if I hadn't, been there and said that I want this to be recorded exactly as it was said, because not all jurisdictions have mandatory audiovisual recording. So I think the list is very long, what a lawyer can prevent if the lawyer is there, and what he or she cannot prevent if there's only a phone conversation. But that's all I want to say.
That's wonderful. Thank you, András. And I think your point with respect to intoxicated suspects also works for suspects that need the help of an interpreter and that are interviewed or questioned without an interpreter present, with insufficient language skills to understand and answer questions. And a lawyer's role is also to ensure that an interpreter is present when needed. So we've reached the time limit of this webinar. I'd like to thank you all. Nicolas has disappeared. I don't know where he is, but thank you all panelists for this very fascinating and interesting conversation. I hope this was as, I'm seeing in the chat that we have a lot of very positive feedback. People were we're satisfied with our discussions and the points that were made. So thank you all, and thank you for all the attendees. This webinar will, in principle, be posted on our YouTube channel shortly. Thank you all. Bye-bye.